4 wonderful panelists. And what we're going to do, and the way this is going to work today, is each one is going to say a few words about their thoughts on technology competence and the practice of law. And from there, we're going to go into a series of questions on technology competence and the practice of law. So thinking about starting at the end and working this way.
Of course, you're going to keep us on our toes. Right. Hi, everyone. My name is Stan Pearson, and I work for a software company called Relativity, which is a legal services software developer and platform. I'll put in a plug for my session after this. Stick around. I'm going to do one of the labs, so come, and I'm going to talk a lot about relativity and various careers around technology. But I was a legal practitioner for a number of years. I had law as my second career. I spent 17 years in the hospitality industry and decided I really needed to go to law school. So I did that. It's been 20 years now since I went to law school, and practiced law for a number of years, and then got into e-discovery and loved it. So now I'm kind of, have been referred to as a techno lawyer. I'm not sure if that's a good thing or not. But my feelings around competency and technology are really that I don't think being competent in technology is different than being competent in any other area. If you're going to practice law, you have to know what you're doing to serve your clients, which means keeping abreast of the latest technology. Not only the ABA rules require it, but your own ethics should require it. So I just think it's important, and that varies obviously from matter to matter, from client to client, but I think it's imperative now that we stay very informed about the new technology and what's coming in technology.
Okay, my name is Ken Rumelt. I'm a professor and senior attorney at the law school here in the Environmental and Natural Resources Law Clinic. I think that technology is an important part of the practice of law, particularly in the environmental field, or in any field really where you're handling a lot of information. If you're not able to access that information, whether it's through discovery of opposing parties or through Freedom of Information Act requests or your own client's data, and if you don't know how to access it, manage it, organize it, review it, produce it, and use it, whether in motions or at trial or whatever you're involved in, I don't know that you're really doing the job that your clients are paying you to do or what the law expects you to do. That's not saying everybody has to be a technical genius, but you at least have to have some competence and ability to handle all of this information. And I just wanted to give a small example of that. We had a case a number of years ago where we did a Freedom of Information Act request to a state agency on a site that had been, it was 600 plus acre, what's called a waste coal site. And there were decades of documents, all in paper copies, at the state agency, okay? But in a lot of states haven't come up into the age of technology yet and still maintain their files in hard copy, which makes it difficult to access. Now, excuse me, they had probably 10 to 12 banker's boxes worth of documents. And if you don't know what a banker's box is, you're probably better at technology than the people who do know what a banker's box is. But these are boxes that are about this big, and I think they've got about 10,000 pages in them. Is that about right?
That's about right.
Okay, now if you're going to get a copy of 10,000 pages at 20 cents a page, how much is that going to cost? I'm not good at math. What is that, 2,000? 200? 2,000?
Yeah, 2,000.
Okay, good. I was originally a science major, then went to law. But anyway, that's a lot of money, okay? And that's something that if you want to access all that information, you might not be able to afford it. Unless you have a couple students with you and you have 2 portable scanners and a computer. We were able to spend a couple days, miserable days, scanning documents, gathering all the information we need, bringing it back to the office and having our own document database. We would then OCR it Now, that's another lovely term of art that not sure everybody knows, optical character recognition. Basically, you're turning an image into a searchable text file. We did that. We loaded it into a competitor's software.
You can name names.
Yeah.
Concordance. It's a Lexis product, and we were able to then have this huge trove of information. Now, the great thing about it is that because we were able to get everything and we scanned every page, we determined and we found out that they didn't give us the really important stuff that we had actually asked for, right? And then we used that, that ability to say, look, we've got everything you gave us. You didn't give us the good stuff. And we went back and challenged it. And then, oh, it was somewhere else, But anyway, this is just an example of knowing how to use technology to do something in a cost-effective manner, in a timely manner, for the benefit of your client. And I'll just say, I think that's an important skill to have. There's a fair amount of learning curve in doing some of this work, but either you're gonna have to do it at some point, or someone's gonna have to pay another person to do it. So I'll cut my remarks off there.
No, that's okay. You can, the point is, if you pay someone else to do it, right, that means your fee as an attorney goes up and you're less competitive, right? And that's the upshot from that. Is there good enough?
Well, and also, if you rely on someone else to do it, it may not be done right. I have 3 quick stories, including one on myself today, I discovered. This is 3 tips that will stand you in good stead. First of all, fully understand what reply all means and do not use it. Okay, never hit reply all unless you've thought about it, because that's a good rule, number one. Second rule, which you may not be as aware of, is that if you send a file to someone in a Word document, the Word document carries with it often the metadata for all the prior versions. So you can if you're good and somebody sends you a Word docket, you can go back in and find the track changes and everything else that's hidden behind it's often recoverable. Do not send the other side Word documents. Even PDFs carry a little bit of data, but by and large, just PDFs, please. Tip number 3, and this is on me today because I see my property class here. Always go to the end of the assignment you just gave your students. I think you'll find that when I gave you that website to go and use, I said free, and when you got to the end, it wasn't really. Anyway, my apologies. I've got alternate directions. Those of you who did go all the way through, terrific. But unsubscribe within the next 2 weeks, and they won't charge you anything. So that's the one where you go all the way through.
Are you getting a cut?
Am I getting a cut? No, I'm not getting a cut on this one. A quick little taxonomy that I find useful when you're thinking about what does it mean to be a competent lawyer, is that actually technology really comes in kind of phases, and I sometimes characterize it in 3 phases. Phase number 1, 1.0 if you like, version 1.0, is when the technology helps lawyers do the things that they're going to do. Word processing does that. LexisNexis, Westlaw, Bloomberg, the various search engines do that. Some law practice management may put one of your office managers out of business, but you as a lawyer are empowered by that. These are things that actually will up your productivity and not compete with you. That, as an entry level, everybody in this room needs to have some competence with. Why? Because if not, you're just not up being a good lawyer. 2.0 is interesting because under my 2.0 classification, it helps you do the things that lawyers do, but it replaces some lawyers. And this is a little bit of a threat for us, right? And kind of, oh, we're lawyers, how's that gonna go? You need to know how to manage that process, or you'll be as I say, you can drive the car, or you can be roadkill. It's a kind of a Vermont, not terribly polite thing to say. So you want to be able to understand this stuff and manage it. So competence isn't just kind of entry level. I can use it as a kind of entry level consumer. Competence really also then extends into understanding and being able to manage this stuff. So that somebody like your service, I can manage my time with you. If I can't manage him, and I was just that e-discovery associate in the law firm, I just got replaced. So that's, and a third level is really where it gets quite interesting to me. The 3.0 is when actually the way the law works changes because of what's going on. There are certain kinds of online dispute resolution, which is really kind of a different way to go about it. There are other examples we can talk about, but imagine yourself into the world where it's not just you're aware of how to be a consumer, you're aware of how to manage the product line, but you're even thinking into what's next, what's going to undo me, what's going to be out there. This financial technology, blockchain stuff that I've been working on a bit, and that our property class will talk a little bit about in the next week or so, is a piece of that kind of thing. So imagine yourself competent not just at that kind of entry level, but competent at the management level and competent as an innovator and visionary as well. All those are all levels of competence, which I think you'll find you'll benefit from.
I guess.
Go ahead, David.
So my name is David Colarusso. I help run the Legal Innovation and Tech Lab down at Suffolk University, where we sort of work like a consultancy, having students build legal tech and data science projects for outside clients like courts and nonprofits. And so I often get sort of pigeonholed as like the coding for lawyers guy. And one of the things I always like to say, though, is technology competence isn't about having everyone deal with mastery. It's about literacy, right? So we all write, but we're not all going to be novelists. The important thing I see is understanding technology to the point where you know what's going on, so you can call BS, and so that you actually understand how things integrate. Right? So somehow we got all the way to me without anyone mentioning the ABA's model rule 1.1, which is the rule on competency, which has now been, some version of it has been adopted in now 30 states, which also has a statement about tech competency. So, right, it's like, to maintain the requisite knowledge, skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risk associated with relevant technology, right? So the question as to whether or not you have an ethical obligation. In a lot of states, you have a black letter ethical obligation. Now, to tell you a quick story to illustrate okay, what do you mean by know how things work? So I used to know a large criminal defense firm who had a rule that nothing would go in the cloud, right? No cloud-based practice management, no cloud-based anything, because the concern was, even though they knew at some level that the security would actually be better if it was maintained by a big outside contractor, they were worried about national security letters, right? They had foreign nationals who were clients, who were accused of doing things, and they knew they could come with their toothbrush and ready to go to jail for the night, but they didn't trust someone else to not hand over their data. Now maybe that's a little paranoid, but that was where they were at. So that's maybe that's the right decision, maybe it's not the right decision. And then what did they go and do to save money on their phone service? That's right, voice over IP. Where were those voicemails being stored? That's right, a third-party server, right? So the question is, if you don't actually understand how things are working, you might think you're doing one thing, but you're not really doing that thing. So it's important to understand how things work, just so that you can be keeping up with what you say you want to do. And so maybe that makes the question, it's like, oh, okay, are you okay with this? Well, then maybe we're okay with something else. Or maybe we're not okay with this now. But if you don't understand how things actually work, then you open yourself up to a lot of problems.
So I noticed, David, when you told that joke, which I thought was a joke about the voice over IP, that not a lot of people in the audience laughed. So I guess my first question back to the panel is going to be, and since you told the story, David, can you explain why that was funny?
Okay, so the thing that was funny was that there was this, so I've obviously failed, right? Because whenever you have to explain a joke.
No, this is the tech competency, and this is actually illustrating, within this room even, the point we're trying to make here today.
So obviously, if you have to explain a joke, I've failed as a humorist, so that's okay. Maybe I can succeed somewhere else. So voice over IP is the technology that Skype uses, is probably the most familiar people are with, and it's the notion that you can send voice calls over the internet. The point is that they were taking something that was hardline communication from phone to phone, and then they opened themselves up to all these interesting questions by pushing that information over the internet. So one thing is a question as to whether or not the same wiretap rules apply. So is there now of course, they're in a unique position because as a law firm, there are confidential client communications, so hopefully the government would not just go listening in. I mean, let's not ask any defense attorney, maybe someone's currently who are down in Gitmo who find a fun little device in their room and are like, what's this? And if you aren't familiar with that, that was recently one of the cases down in Guantanamo Bay. They found a listening device, the defense counsel did, and they're like, what's up? And they're like, oh, no, it's, and if you're following it, I can't remember the name of the case right now, but it's the person who was charged with the USS Cole bombing. And the notion was they found this thing, it looked like a listening device, and they complained to the court. They're like, what's this? Have you been listening in on our conversations, our privileged conversations? And they're like, oh, don't worry about it. Of course, they were more than that. They were more like, no, this is classified. You can't talk to anyone about it. It's not a big deal. So I don't know. I come from a criminal defense background as a public defender, so maybe I'm not always giving people the benefit of the doubt. But I think that's, what the adversarial system's about. Anyhow, the voice over IP joke. You see, look what she didn't know she was going to start here. So that firm I was discussing had made a determination, or at least their outward expression as to why they didn't want to move into the cloud, was because they were afraid about people being able to access their information by going to a third party and getting it from them without them being the gatekeeper to that information. Voice over IP, you have a third-party service who's maintaining that, and more than that, that information is flowing over the internet. So whether or not that was encrypted is an open question, and then it's sitting on, the voicemails are actually files now sitting on someone else's server, which means that they're now doing the thing that they said they didn't want to do, which is store any information on a third-party server. So by not knowing, and this came about because the phones were handled by facilities, not IT. So there was a lack of understanding as to what was actually going on, and none of the top brass understood, oh, voice over IP, maybe we should involve IT or ask them, and we have this policy against no cloud servers. And so they were violating their own policy without knowing it. So that was the joke. Oh, that was the joke.
Yeah, see, there we go. All right, so thank you, David, and gracious as always. Transformational uses of technology. I would like each of the panelists to think through and talk about, for us, a transformational use of technology that has impacted you in practice, or for those of you that aren't practicing at the moment, that impacted one of your students when they practiced. So if we could go in whatever order inspiration strikes you.
I don't mind to start with that one. I think transformational use of technology happens, it seems like it happens a lot these days, but I think the biggest thing, and it's pretty overarching, and that is the idea that now we have e-discovery, which is the only kind of discovery. There's really no more, I don't think anybody's using banker's boxes anymore, at least not what I see. And I will admit that I live in kind of this tech bubble world where we think everybody already knows all about the technology, and we realize that there are people every day who are still dealing in paper, but not so much.
We just explained the voice over IP joke,
Yeah,
so yeah.
It's called the criminal bar.
Right. But I think that brings up something that, and I thought about this with the voice over IP, I think one of the competencies that we have as attorneys is not only to know what technology we're using, but what technology our clients are using. So that when we go to advise them, we have to know what's behind their firewall, what do they use to communicate with each other in-house. And the transformational thing that I'm seeing develop now, and I think it's huge in the way that we deal with one another as attorneys, and that is the whole idea of predictive coding and artificial intelligence. I think those terms in technology-assisted review, those terms kind of all get commingled. And the way that attorneys talk about analytics is often something that is different than the way a business analyst talks about analytics. We think of analytics in terms of how can we solve our clients' matters the quickest and the cheapest. So for me, that's where I'm seeing the transformation take place, and that's what has affected me the most. And I think it can be used in small arenas as well as huge. And as it develops, it's going to be a lot more accessible for smaller matters, for solo practitioners or small firms, or government entities that are working more for indigent populations or pro se clients, whereas now government entities that use artificial intelligence or analytics are just dealing with the second request from Exxon whenever there's some kind of securities matter.
Or Cambridge Analytics, right?
Or Cambridge Analytics, yes.
So what I would ask you to do is explain a little bit for the crowd what computer-assisted or technology-assisted review is, just shortly, so we're all on the same playing field.
Sure, just real quick, and I will go more into this later actually this afternoon, but it really is a way to try to organize documents based on concepts and try to classify documents really for responsiveness or not responsiveness when you have a huge data set and you want to call that data set down quickly. So it's being able to review, say, a 30 million document set and really narrow that down to having to review only 50,000 documents.
Super, thank you.
In my practice, I'm mostly dealing with, and am, kind of a public interest environmental lawyer. So we don't have resources to afford, frankly, some of these brand new technologies. So what I'm seeing mostly in practice is that my colleagues are using technologies to help reduce costs, whatever that may be. So something like Dropbox, or all these services as software, cloud computing, basically. So a firm might try to save a fair amount of money by getting rid of its IT department and instead just running Dropbox for Business or one of the other services. In addition, while not everybody has adopted it, I've used Microsoft OneDrive and the ability to edit documents collectively in the same version of the document with multiple people editing at the same time. So I found that helpful, although sometimes it's been problematic, But the point is, you're looking for cheap gains in efficiency as far as using the technology. This is the 1.0 that Oliver was talking about. I haven't seen a lot, frankly, of the 2.0 or 3.0 in my practice, except for when, for example, I have to figure out how to load a huge database file into a concordance, and it takes me a week and a half on the phone with the company to try to figure out how to do it. So that's what I'm seeing. But in the future, I think it's interesting. We're probably many, many years away, and I'm going to say this to sound smart, but quantum computing, at some point, what are we going to do about keeping things confidential? Because from what I've read, it seems like we're not going to be able to have the same level of secrecy that we had, and we'll be living in the world of sneakers, if anybody remembers that movie from the 90s.
So for those of you that are wondering, SneakerNet was when you ran from one computer to another with a USB key, and that was how you sent files back and forth.
That floppy disk, yeah.
Oh, no, I'm talking about the Robert Redford movie.
Oh.
I know, but I was extending it.
Well, I'm going to shout out some of our current and very recent students, several of whom are in this room, who I have watched have their interest level and their career plans transformed, hopefully for the better by interacting with tech. I mean, for instance, Chloe and Brittany, right? They were here just a moment ago. Now they're off organizing, I guess. Again, both they have had terrific engagement. I mean, imagine organizing something like this as a piece you do as a student. And the degree of engagement with the subject matter, the people, the ability then to take that on as use this as a stepping stone for a career. All of that is. I was just calling you.
Shouting you out, Chloe.
Calling you and Brittany out as folks who have been transformed a bit by some of this technology. Also, recent students, Jordan, who is here, Kevin, who has been here. They both founders of companies in the last year or two, and are working hard to make it go. It's an uphill battle. 1 in 10 makes it. There we go. But you take a shot and you do your best.
I'll toss in Stephen Curry as well,
Yeah,
who started a company called Voltage.
There we go. Again, a graduate last year, a couple of our 2 or 3 of our graduates in the last year have become legal entrepreneurs in this. It's a rough go. I'm not going to say that it's for the faint of heart, but it is one of those things that can transform you. I've seen it in our student body and in our recent graduates as being potentially transformational. I'm going to mention one other little distinction here, or major distinction actually, just to help clarify some things. The difference between what is essentially a rule-based approach and a data or AI-based approach. Because you can structure a legal interaction based on rules. Our expert system kind of approach is typically this, where you set up the process and bake in the rules. TurboTax is this kind of thing, where the rules are baked in. And that's distinct typically from this kind of machine learning AI piece, where you turn the machine loose to learn the patterns and to tell you patterns that you wouldn't have found otherwise, which is what a lot of the e-discovery predictive coding piece is. In some ways, you're looking for what I say, the signal in the haystack. You're looking for the machine to help you find signals you weren't aware of. The rule approach, you build them, you bake them in from the ground up. So anyway, it's worth just keeping in mind that when we talk about these technologies, when you hear about AI is typically referring to this kind of data approach, but the rules approach is also out there.
So I want to double down on, I don't see him anymore, Quentin from one of the earlier, oh, there he is back there. Spreadsheets. That's what I'm going to go with for transformative. And I'll tell you a little story. So some of you might be familiar with the name Annie Dukin. She was a chemist in Massachusetts who worked at the state drug lab, which is where they would send the samples of purported drugs to be tested to determine whether or not they were in fact drugs. Because, right, if you're selling someone a thing of sugar, it's different than selling someone some drugs. Or baby milk formula, or what have you. So you have to, in order to get that conviction, you actually have to prove up that they are what the prosecution thinks they are. Well, so funny thing, although not funny at all, about Annie Dukin was that she was falsifying drug reports. And very often she would just not do the report. She'd say, oh yeah, that looks like it, yep. And she'd say, yep, drugs. More sort of sinisterly, she would say, oh, how much is that? 17 grams. Well, what if it was 14? Any of you who know anything about our drug laws know that sometimes that 1 gram difference is the difference between many, many years. So of course, when I tell the story, people are always like, why was she doing that? And that we might never know. Although I think she sort of, this is one of the reasons why I think you need to have independence between testers and prosecution. I think she thought she was helping the good guys. The problem is that inevitably, she probably put innocent people away. So this was a big deal. This got discovered, and then they were like, okay, we got to figure out how many cases did this affect? So she was working at this state drug lab, which took in samples from, I think, about half a dozen different counties in Massachusetts. And so what they did is they sent someone in from the executive branch. They came in, they looked at the lab, they looked at all their paperwork, and there was this piece of paper that went along with the samples from the police up to the drug lab called the drug receipt. And it had a little description of, sort of what they thought it was, who the defendant or defendants were, and in the end it would be signed off by the person who tested the drugs, either be a primary chemist and a secondary chemist. And so what they did is they collected all those pieces of paper, and they said, anytime we found her name as the primary or the secondary chemist, we will put this case on a list, and that's going to be all the people who were affected. Okay, great. We got this list. How are we going to give it to people? We're going to make a spreadsheet. Okay, now, I started off with spreadsheets, because I said it was going to be transformative, and now you're thinking, oh, right, this is the hero. Everything's in No, this was the horrible part of it, because the spreadsheet, do you know what was on that spreadsheet? Here are the columns, or at least the relevant columns. Defendant's name, sample number, police department, what they thought it was, what the test came back as. That was pretty much it. Okay, we now have a list of names and all these stuff. Man, I wish there were docket numbers. Juan Carlos Ortiz, I'm sure there's only one of those. So I know who that is. right? So the problem was you had this list that was responsive in that these are all the people we think are effective, but was entirely unhelpful. And so this created a lot of litigation. It actually just sort of finished up. About 20,000 cases have now been thrown out because of what Dukin did. But the thing that really irks me is I still think we're missing some of the folks. So at the time this case came through, I was the data scientist at the public defenders in Massachusetts, and I was asked to look at some of this data. And the attorneys in our office, and I'm sorry it's taking a long time, I just get really excited about this story, because it's about spreadsheets. Just wait. So some of our attorneys, when they were looking at this, they're like, wait a second, well, that list you put together, you never went back and talked to the police departments, you never did any more information. All the different police departments have slightly different forms they sent up. Some of them in that spot for defendants, some of it was just a line. Some it was 4 lines, some was a little box. What happens if there were multiple people who were charged? And was it practice that they always made it on that list? What if there was someone who didn't make it, there wasn't enough space? What if there was someone who was charged with these drugs, but we don't have them on the list? DAs were like, it's got everyone. They said this multiple times. You can go back and look at the record. They said, oh yeah, no, it's not a problem. So what I did is I came in, so in Massachusetts we have a sort of hybrid system. We have staff attorneys and we have panel attorneys. So we didn't have the records of our panel attorneys, but our staff attorneys we had. So we could look at this list they put together, and we looked for all the cases where we had clients who had the same name, out of the same court, around the same dates. And what we did, here's the transformation, we did what's called a join, which is that we took that table of information, if you think about it, and our table of information, and looked at all the places where the names matched. And what this did was give us a list of not all of, sort of a fuzzy list, right? Because we were matching on names. We didn't have date of birth. We didn't have any other identifying information. But we basically established that here is a subset of those people that we had as clients at the staff attorney side. And then what we did is we said, we know from our content management system who all their co-defendants were. If the list is really entirely inclusive, like the DAs say, those co-defendants should be on that list. Okay, let's see. How many were missing? Well, we didn't have all the cases, so we had to extrapolate, but somewhere between 0 and 10,000. And we knew that it wasn't 0 because we pulled a couple of those police reports, and then you'd find a police report that was like, oh, so-and-so was, arrested for possession of whatever. It came about because of this search warrant that was executed on Tuesday. And you're like, where's the police report on Tuesday? You go back on Tuesday, you find the police report, find out there's someone named in that police report who wasn't named in the other police report, who wasn't on the list, but was charged with possession for the same substance. And then you're like, there are clearly things missing. And so that went up to our Supreme Judicial Court, and that's the sort of stuff that then you note, because you were able to sift through all that information, but really all it was we knew how to take spreadsheets and do a join and say, this one and this one, where do they match? And that was like magic. It's really sad that that's like magic, but that's the sort of stuff that you can do if you know how things work. And I had a student who, and I'll just say to end up the spreadsheet conversation, had a student, we're teaching them how to do this sort of stuff, do these joins. He was working as an internship at a job and with a small firm, and they got all these spreadsheets in, and they were trying to figure out how to make sense of them. And they realized they had these common elements. They were gonna have to pay some outside firm tens of thousands of dollars to investigate and put them all together. He's like, we could just join them all together in one table and poke around and see what happens. So he did that, and they're like, you're great, you're amazing. And then what they said is, because his internship's about to end, it's like, if you want a job, right? So that's transformation because it affects people's lives, just being able to sift through stuff. And I've said enough, so.
Although the employability piece, unless you're going to get to that in a minute. Okay, I'll let you do it.
No, go ahead.
I'm just going to say that in a tight employment market, being able to have some of these skills and some of this skill base can be a differentiator. Particularly as the more senior attorneys in any organization, whether it's a public defender or a prosecutor or a law firm or a company or a nonprofit or the government or whatever, tend not to be as up to speed on this stuff as they might be. And if you can come in and actually flip the expertise a little bit and say, hey, yeah, I actually do know how to do some of this stuff and I can be useful on that, that can be a nice way to differentiate yourself from the rest of the market in the employment decision.
Was it a left join or a right join?
So in this case, it would have been a left join. Yeah.
I dabbled with access, trying to figure out how to, and this is another big data thing, is trying to figure out how to take compliance data that's available through, EPA or a state agency and some other data that's out there on facilities and try to figure out who doesn't have a permit and who needs a permit. And I don't think I kind of got there, but I wanted to make it kind of automatic. I'm not a computer scientist, or I'd never really worked with databases before, but like that's the kind of thing that I envision trying to do with technology that can be transformative. Compliance, we have data that's out there now, and we've got lawyers who know what non-compliance looks like, and what if-then conditions lead to finding somebody who isn't complying, and then can actually do something about it. But we don't know how to necessarily get the data to match up and spit out the answer that we need, and then rely on it. So databases are great if you know how to use them.
So I think we're getting to the place where we've got to wrap up for the labs, but I'm going to throw out 2 questions. You can pick which one you'd like to answer, panel, and you need to answer it in about 1.5 minutes or less, okay? So lightning round. So here are the 2 questions. If technology is replacing lawyers, are we being asked to have competency in our replacement? And isn't that a little counterproductive and, well, not a happy career choice? Second question, we've spoken about the requirement of technology competency, and no one has mentioned the standard. There has to be a standard. What's the black letter law? How do I know I'm competent, technically competent to be an attorney? What does that look like? And I would leave it to the panel to pick the question.
Well, I'll start.
Okay.
So they're both very intriguing questions, first of all.
Always
And-
compliment the moderator.
Yes, that should help.
And he's
but-
got to go first for doing that.
But I think the first question is the one I'd like to answer, and that is, really what I got from that is whether people or whether machines will ever replace lawyers. And I think that is absolutely not going to happen. With all the machine learning that we see, with all the development, I think it's all designed to help us as lawyers. It's all designed to help us do our jobs. Now, what it might do is hold us to a higher standard. And a minute ago, when Oliver was talking about the lawyers that you might go to work for who don't know anything about technology, who might not even understand how to send an email, and they still exist. They are still practicing law. And they're not even old necessarily. You might have young lawyers who are Luddites, who have absolutely no interest in learning anything because they were taught by the old lawyers when they started in the firm, and they think that it's not part of their duty as an attorney. But I think all the technology that we have will only serve to make us better, but it will also keep us active in learning efficiencies. And ultimately, that serves our clients the best, because what they're concerned about, whether you're representing ExxonMobil or you're representing somebody in a housing situation that was kicked out for no reason, you have to understand that that person just wants to win, right? And you want to do the job for them at the lowest possible cost with the highest efficiency. So machines will help you do that. And all the technology that we've talked about, starting from spreadsheets all the way up to the most advanced predictive coding tools, are going to help us serve our clients better, but there's never going to be a need for no human input.
As far as the competency question goes, I think the rule I would, in my own little world apply is that you have to be competent enough to know when you're not competent enough to represent your clients. So, and then if you're not competent enough to do it, you have to at least know to hire somebody. So, what that level is probably depends on who the clients are, what kind of case it is. And that's something that I think lawyers wrestle with a fair amount. Is this the kind of case that I know how to handle? Am I able to handle it? Do I have the resources to handle it appropriately? That's kind of my easy answer. That's probably, I don't know, others.
So I'm
tear it
going to
apart.
sum that up in a couple of words. Hire a third-party expert, right?
Yeah.
Know when to hire a third-party expert.
Right. And then as far as, oh, I'm
No,
sorry.
no, go ahead. No, go ahead.
Well, I generally think that there may be a time when technology replaces the lawyers, but it'll be that time when we're looking for Sarah Connor to rescue us from the Terminator. So, sorry, that probably wasn't worth delaying.
No problem. Two things. One is that, to go back again, I'm encouraging you all to imagine yourselves as that third-party expert. If you know better than Ken does about how to do some of this stuff, he's got to hire you. Which leads me to my second point. I'm going to be the contrarian. Yes, we've already lost lawyer jobs to this. It's happening. It's out there. Let's not be Pollyannish about it. It's happening. Our job at this law school that we're trying to do, and that other law schools like yours are trying to do, is to make sure it's not your job that gets lost, okay? There will be jobs lost. They're happening now. The e-discovery, the early on thing, predictive coding wiped out thousands, if not tens of thousands of associate jobs. It did. There we are. You can say the partners are doing better, okay, but those folks got pink slips. I don't want any of you students here to get a pink slip because you didn't have the competency that we're talking about here. So that's why we're trying to push you there. Is if we can make you competent in this new world, you won't get that pink slip because you'll be one of the ones who's needed.
You'll manage the technology process.
I've already spoken a lot, so I'll keep it short. As to the second part of the first question, no.
Why?
I was really trying not to talk.
I know.
I don't think, so the second part of the first question, as I remember it, which I might not remember correctly, was about whether or not there's sort of an ethical problem with training our replacements, basically. And I would say no, because as a profession, we're trying to do the best by our clients. And I don't think we're going to get rid of lawyers until we have general artificial intelligence, and then everyone's job is gone. And maybe we won't need Sarah Connor, because maybe it'll usher in a great new world of happiness. But your job is to your clients, is to give them the best. That's your ethical duty, is to be a zealous advocate. And however you can do best by your client is what you are supposed to do. It's why we're a profession. It's why this is, I don't know, it's why you become a lawyer, right? Because you're gonna go out there, you're gonna fight the good fight, you're gonna do well, I don't know. That's why I became a lawyer.
So I would suggest that if you're not technically competent, you can't do that as well. And I didn't know is no longer an excuse.
You're here.
Should we?
Questions? Are there any questions before we head out to the lab?
Hi, good afternoon. Thank you all for being here. My name is Rinku Kapoor, and I'm an outgoing 3L. And just to reiterate a few of the comments that you guys made, I was just at an interview recently where the judge asked me, and she's like, I'm not competent in technology, and I'm looking for a candidate who is. And luckily, I grew up with, I'm older, I grew up with a 386, so my father taught me how to go with technology. And I grew up with Word when Word you needed to save it every 2 seconds. We found my father's brain tumor that way. Long story, like you said, it just goes off track. But point being, I've grown with the technology, and I'm lucky that I had that opportunity. I've worked with younger students here and classmates who don't know where that technology has come from. And it's harder sometimes to format things and understand that. But anyway, where it comes to jobs, technology I've been lucky enough that, I knew where there was a mobile parking app, so I just used that to do, and those little things do help, and they actually help you get in through that door.
Absolutely. Thank you for your comment. Other questions, comments?
I have a question, if no one else does. Ken, you mentioned that the Energy Clinic uses Microsoft OneDrive in your legal cases. So I'm just wondering, so data sets are used for discovery, and I'm wondering what mechanisms does Microsoft OneDrive have in order to ensure the integrity and authenticity of your legal documents and also the protection of your clients? And how hackable is Microsoft OneDrive?
So, first of all, I've not put, data per se on the cloud for any of the work that we do. And I just distinguishing between the energy clinic and then the environmental clinic, because two different clinics. But, and we use it for very specifically drafting a document. As far as keeping the information secure, we're relying on Microsoft to do that. And there's days where I feel like Microsoft may do a better job than we can here. Sometimes, it's such a critical brief that we need to get done. And the wind is blowing more than 20 miles per hour in Vermont, so we're likely to lose, internet service. We might have to do
Power
something else.
outages.
Right. So there's drawbacks to, maybe Microsoft will go down, maybe our internet at the school goes down, but we're working with other lawyers in other parts of the country, drafting something together. So it's a choice. But I just generally rely, my general take on things is anything's hackable. And the question is, what's the risk?
There are, in many states now, ethics opinions on exactly this subject of the use of cloud for confidential material. And my impression, although I've read a number but have not done a survey, is that most of the states are saying that that is okay given certain kinds of safeguards of password protection and things like that. There are, I think, a few that have said that no, you shouldn't. But depending on where you're in practice, that's one of the kinds of things you should look up and just be aware of as being competent in this area is figure out what the local rules and standards are for your jurisdiction.
And I would add to that, watch the rules change, watch the decisions evolve. Originally, most of those ethics opinions said that lawyers were under no obligation to encrypt email and to encrypt transmissions and communications. And now they're going in the other direction. So there is a trend to be rather laid back about security and then tighten up as we all become aware of how important it is.
And
Sorry, I was just going to add, if you're dealing with client data and you're in a position to decide what you're going to do with that client data, the number one thing on their mind is going to be security. So you're going to have to learn. You don't have to learn exactly how it works, but you're going to need to know that wherever you decide to place that data, you have to be able to assure the client that data is safe. And whatever the rules are, to make sure that you're following those. So that's kind of a twofold decision you have to make.
And I would go right back to David's BS meter. This is why you have to be technically competent enough to know if somebody's selling you a bill of goods or they're telling you the truth about how secure the information is. And if they're technically competent to hold your information, store your information, and provide those services.
And there are now actually services out there, specifically lawyer clouds, which at least purport to give you another layer or two of security in there if that's a concern.
right, I had one case where we obtained highly sensitive confidential documents during discovery, and I would not share that information electronically via email. I would, we had a cloud service, we looked at their licensing agreement, and they can establish a secure portal. And that's how I was able to share highly confidential documents that if they got out, I'd be in big trouble with experts on our team.
I'd also just say, make sure you know your state's data reporting rules. So there often are statutory requirements for certain types of data if it gets made vulnerable that you have to report. So, if you that often comes out if you have a thumb drive and you got client files on there and you leave it on the bus, you're gonna have to tell a lot of people.
And I would just point out all 50 states have some rules related to notification for data breach. So.
Thank you all. That was a great panel.
Thank you.
So we are about to move into our last round of labs. You can either attend